Hello friends, in the series on the income tax cases, today we will discuss the case of Nisarahmed Abdulsattar Shaikh versus Income Tax Officer. This case has been reported in 107 ITR Tribunal at page number 233 and the matter has been decided by Ahmedabad ITAT C bench. And the date of the judgment is 30th June 2023. This case is regarding penalty under section 271CA, which talks about penalty for failure to collect tax at source. In this case, the assessee was in the business of scrap. The assessee has sold the scrap and the assessee has not collected the tax at source, due to which the notice was issued to the assessee that why the assessee has not collected the tax at source, and accordingly the assessing officer passed the order against the assessee for the tax amount and the interest amount. The assessee was before the CIT appeal. For this matter, the assessee could not appear before the CIT appeal and the CIT appeal passed the ex parte order. The assessee moved to the ITAT. At the time of the proceedings before the ITAT, the assessee came to know that the order has been passed beyond 4 years from the end of the financial year for which the matter was related. So the assessment order was time barred. The order for imposing tax and interest was time barred. So the assessee raised this ground for the first time at the time of the proceedings before the ITAT. The ITAT allowed the additional ground on the basis that the technical ground can be raised at any time and the ground which goes to the root of the matter can be allowed at any stage of proceedings. The ITAT allowed the appeal of the assessee on the ground that the order was time barred because it was issued beyond 4 years from the end of the financial year for which the matter was related. In the meantime, the assessing officer passed the penalty order against the assessee. The assessee moved to the CIT appeal. CIT appeal confirmed the penalty and now the matter was before the ITAT for the penalty proceedings under section 271CA. It was the submission of the assessee that since the quantum appeal has been decided in my favor for the tax and interest, so there is no question of penalty proceedings. The ITAT was convinced with the assessee with the submissions of the assessee and allowed the appeal of the assessee on the penalty matter also. Friends, there is no doubt that when the quantum appeal gets in favor of the assessee, then there is no question of any penalty. But with the due respect to the Ahmedabad ITAT C bench, there are some judgments of the High Courts also, which says that when the quantum appeal has been decided in favor of the assessee, because of the technical grounds, like the orders have been passed without taking the proper approval, the orders are time barred. In those cases, when the assessment orders are time barred, the penalty cannot be dropped because the technical grounds cannot remove the penalty provisions also. When the quantum matter is decided on merits, the penalty proceedings do not stand. But there are some views of some courts that when the quantum appeal is decided in favor of the assessee on the basis of some technical grounds, then in those cases the penalty proceedings can sustain. Although in this case the Ahmedabad ITAT gave its decision in favor of the assessee. Friends, this case is very important because first of all it gives a message that we have to first of all and assure from our records that whatever the orders have been passed, whatever the notices have been issued, whether they are within the limits of time or not, because once they are time barred, the whole proceedings can vanish. At the end of this video, once again I am repeating the name of the case. The name of the case is Nisarahmed Abdulsattar Shaikh versus Income Tax Officer, and this case has been reported in 107 ITR Tribunal at page number 233, and the matter has been decided by Ahmedabad ITAT C bench, and the date of the judgment is 30th June 2023. Thank you, friends.